Kekana, you have been found guilty of dishonesty, correct?
That's incorrect.
All right. You have not been dismissed because of dishonesty?
No.
Did you distribute documents that were sent to you by mistake?
Chair, as I indicated before, I will not have a view on the issues which are pending at the Labour Court.
No, Mr. Kekana. You have a view about issues that are pending before the criminal court in respect of the public protector. So you think you are the only person who has rights in South Africa?
Chair, I've indicated my view.
Well, Chair, can you please direct the witness to answer the question, because I told you about the double jeopardy and you said we must go ahead. It can't apply only to certain people. Please, Chairperson.
Just repeat your question, and I would like him to repeat his response in the manner he deems he wants to do it.
All right. Okay. I'll repeat the question. Let me just put it. If you bear with me, Chairperson, just for. Yes. Mr. Kekana, your disciplinary hearing was chaired by Mr. Fourie, correct?
Yes, that's correct.
Yeah. Okay. Now the part I'm just going to read some of what he says. It says, in my view, the employee disregarded and breached the relationship of trust between him and the employer by disclosing confidential information that was sent to him in error, well knowing that it was not meant for him. His relationship as a shop steward with the Public Service Association and the advantage that it could gain from confidential information it came to his attention by mistake was at the time of more importance to him than his duties and responsibilities as an employee. And then at 14, he says, however, this was denied, the employee showed no remorse for disclosing confidential information during the proceedings. He initially suggested to Ms. Mafa that she deliberately disclose information to him relating to travel arrangements of the former chief executive officer after she had discussed it with him. However, this was denied in his evidence. Instead, he agreed that Ms. Mafa provided the information to him by mistake. In my view, this indicates dishonesty on his part and a late attempt to shift the blame. You remember that part?
Not that clear.
You did receive the outcome of your disciplinary hearing, correct?
Yes, I did.
And that's what I was reading from. Have you forgotten now, or is that a convenient way of forgetting it?
Maybe when you started, I disagreed with you, and I still disagree with you that I was charged with dishonesty. I think maybe the way you started confused me because I was charged with unauthorized disclosure of confidential information. I was never charged with dishonesty.
No, that's it's probably the way I phrased the question. I'm sorry, Mr. Kekana. The question should have been, were you found guilty of dishonesty? Were you found to be a dishonest person?
Councillor, I think you're going there again. You're saying I was found guilty of being dishonest. I just said I was charged with unauthorized
Was a finding,
disclosure.
okay. No, thank you. No, fair enough. Was a finding of dishonesty made against you by Mr. Fourie?
He did mention that, but I was not charged with that.
No, I didn't say, Mr. Kekana, please don't waste our time now. I've changed the question for your convenience. Was a finding of dishonesty made against you by the chairperson of the disciplinary hearing?
No, Chair, I was found guilty of unauthorized disclosure of confidential information.
I'm asking you the last time. Was a finding of dishonesty made against you by Mr. Fourie, the chairperson of the disciplinary hearing?
Chair, I've made or submitted an answer to that.
So you're refusing to answer the question?
He has answered that question in the way.
No, Chairperson. No, Chairperson,
He
please.
just indicated what he was found guilty of.
I'm not interested in what he was found guilty of, okay? So he might say it if he wants to tell people who are interested in it. I'm asking a different question. Was a finding of dishonesty made against you, yes or no? Not what you were found guilty of.
Chair, I've made a view on that question.
Okay, thank you. I've noted that. Please proceed, Advocate Mpofu.
Sorry, Advocate.
Just a pause, Advocate Bauer and Honorable Ngola.
Advocate Mpofu, just as a information, which paragraph were you referring to? In the ruling?
I think it's 13 and 14. Let me just make sure. 13 and 14, yeah. I started by reading 13. The finding of dishonesty is on paragraph 14, 1-4.
Okay, just a pause, Honorable Ngola and then Honorable Sukas.
Well, thank you, Chair. No, I just wanted to request that can the findings of the disciplinary hearing against the witness on stand be shared with us as well, so that we know where Advocate Mpofu is referring from. Thank you.
That's in order. Honorable Sukas.
I just want to know, Chair, just as a point of clarity in terms of the application of the rules, in the witness being uncomfortable or not answering a question, they reserve the same rights, I take it, in terms of being able to respond at a time convenient to them, whether it be in 7 days or not. I'm asking.
That's what I'm on. I'm carefully watching that space. Thank you, Honorable Sukas. Is that being made available before Advocate Mpofu proceeds? Do we have that?
Well, Chairperson, yeah, I'm not taking your job, but there's no such thing as a witness answering in 7 days. The witness must answer now. That is not on the cards, and it's not covered by the directive. But be that as it may, yeah. And so the witness, I'm just saying, yeah, if the witness feels the heat and the over question, he can say, I'll answer it in 7 days.
No, the witness did not speak about 7 days. The witness has been answering questions since yesterday and today. We might not like the answers he's giving. He is giving answers.
Okay, no, then maybe, Chair, you missed what Honorable Sukas was saying. She was talking about 7 days of, that's fine. That's in any event, I was just assisting that the 7 days rule doesn't apply to witnesses.
That's fine. Let's proceed.
Okay.
Advocate Bauer, just switch off your mic. Thank you. Go ahead, Advocate Mpofu.
Yeah. Yes. Please answer the question, sir. Was a finding of dishonesty made against you by Mr. Fourie?
Chair, I've already given an answer to that.
So I take it you are refusing to answer the question.
Chair, I've given my view to that, Chair.
Yeah, I think let's proceed, Advocate Mpofu.
No, Chair, I'm sorry.
He had given an answer more than once. on your question.
Yeah, but Chair, so you can stand up and recite the letters of the alphabet, and you say he has given an answer. He's not answered my question. You can't just say he's given an answer if he stands up and saying
Advocate Mpofu,
hallelujah.
As I indicated, you might not like the response and the answer. He has given his response and an answer to the question you asked several times.
Yes, Chairperson, I'm explaining to you with the greatest respect that I'm expecting him to answer my question. You can't just say because he has moved his lips and something came out of his mouth that he has answered my question.
No,
he has not answered my question.
No, Advocate Mpofu, I don't think we are going to labor the point here. The question has been answered, and he has indicated where he stands on that question. Honorable Melder.
That's it. I think anybody listening.
Just pause, Advocate Mpofu. Honorable Melder.
With all due respect, that is the approach of Advocate Mpofu. Would also perhaps apply the witnesses with the answers that he expects.
I didn't get that. It seems that Advocate Mpofu is being cut out. Honorable Heron.
No, Chair, I'm sorry, with respect, I don't think the response from Honourable Mulder is correct. I mean, the witness has been asked to confirm that in a disciplinary finding, there is a paragraph that says that the witness was found dishonest. I don't understand why it's not correct to put to him, and why he can't answer yes or no that's in the finding.
That's fine. Advocate Mpofu, you seem to have cut out. Are you there? You're muted.
Yes, no, I was removed. So I think that I just saw Honorable Heron literally the last two words. So if you could just maybe summarize, Chair, what he was saying.
No, he was requesting that the witness responds to the question that you've posed again.
Thank you. Hallelujah.
It's fine. Mr. Kekana.
Chair, maybe let me see the document that Council is referring to, and I'll
You don't have that document.
Or no, I don't have it with me currently.
Okay, so are the members.
Sorry, Chairperson. Yes, Ms. Bauer will. I'll move to something else then, Chairperson, for now, just to save time until it has been displayed. Oh, there you are. It's paragraph 14.
Is that the last sentence?
That's correct, Chairperson.
In my view, okay. You want to respond to that, Mr. Kekana?
Yes, Chair, I would respond that that's what Mr. or Advocate Stoffel-Fourie indicated in his findings or in his report.
Thank you, Chair. Chair, there's one thing I would like to raise. In the previous, before we went to tea, there was this issue where the witness that is under oath was somewhat being evasive and refusing to answer a question. Very, very simple and straightforward question. Now, Honorable Mulder spoke and said, Advocate Mpofu must, he must say the kind of answers that he wants. Now, I found that, Chair, to be first misleading because the witness was not answering a direct question. So I would like you, Chair, to also protect Advocate Mpofu because it can't be that a member of the committee is somewhat suggesting that Advocate Mpofu is not happy with the answer, whereas the witness under oath is refusing to answer a direct question. Thank you, Chair.
Thank you, Mr. Zungula. Your point is noted, definitely. Advocate Mpofu.
Thank you, Chairperson. Chair, yes, before I ask my next question, I think I must register this. Unfortunately, thank you, Honorable Zungula. I didn't even know what Honorable Zungula was talking about, because it must have been the time when I was switched off. And I only caught, as I said, the tail end of Honorable Heron's input. So I didn't realize that I had just been insulted once again. I thought today will be the one day that I'm not going to be insulted. Chairperson, I'm appealing to you for protection once again. You have not protected me or Advocate Mkhwebane since day one. Literally every day, I have numerous examples of being exposed, insulted, and not once have you come to my protection, not once. And therefore, it's very important.
Please go ahead, but your recollection of that is inaccurate, and I've done that a number of times. That recollection is inaccurate.
Oh, that's fine, Chair. But that's my view of it, and the record will speak for itself. Also, you're not protecting me from the members. I don't know on what basis Honorable Mulder could say that I don't like an answer. You know, cross-examination, maybe we'll explain it at some stage. Maybe we'll bring someone to explain what is the purpose of cross-examination. Cross-examination has been described as the best engine ever invented to extract the truth by Wigmore, who is an authority on such issues. But it's also the best engine to expose lies as well. And that's what we're busy doing. And one of the ways in which people don't give evidence properly under oath is to evade questions, or to not to answer simple questions, or to give all sorts of roundabout answers. If Honorable Mulder does not know that, then I will, or anybody else, I will bring an expert to explain how these the implications of these things on any process such as this one. But what I will not stand for, Chairperson, is to be abused by anybody. I've made that very clear. I will not be abused or bullied or intimidated or derailed. But it's fine. This is not about me. It's about Advocate Mkhwebane. You can abuse me as much as you like. I will never be bullied. Bigger people have tried to bully me for the past 40 years or so. And
thank you, Advocate Mpofu. I think
so. It will never work with me. So, and I'm not worried about that. I'm not worried about the process. Me, you can do whatever. I mean, you know.
That's fine. Can we now proceed to your cross-examination?
No, I'm not going to. No, I'm going to address you now. And then, so you don't protect me. The members are abusing me. And the other thing I want to raise is about the evidence leaders as well. I also have to place on record, because people are following this process, and we've all said that it's a new process, that we have not, it's uncharted waters and so on. The evidence leaders are not prosecutors. So their duty is to expose whatever, whether it's in favor of Advocate Mkhwebane or against her. Their role is now becoming to look like prosecutors. Even prosecutors, for that matter, have a duty to expose evidence that is against them. So to sit here with a witness who has been found guilty of dishonesty, and it's not in the so-called summary and the build-up, we're told about this case and that case and that case. At that point, we should have also been told that this witness has been found guilty of dishonesty. What if we didn't have it? Because the idea is to assist the members. We might not have had this document, and the evidence leaders have got it, and it's not brought to the attention of the nation, because this doesn't even belong to parliamentarians.
Advocate Mpofu. Thank you, Advocate Mpofu. Because I'd want you to proceed to your cross-examination, but before I allow you to do that, I've made a point here, and I want you to refrain from that. Your recollection of you not being protected in a public protector from the chair is inaccurate, and I want to make that point, and I hope it's not going to be repeated. But secondly, when issues are brought to the attention of the chair, at no point that matters are not being attended to. So I'd want you to proceed to, and at some point, whether later today, I will address you on this point of double jeopardy as a chair, and Indig, because you've just raised something similar to that about issues of prosecution and so on. I will attend to that and address the hearing on that. I now recognize, before you proceed, the hand of Honorable Nodat and the Honorable Lucy.
No, thank you so much, Chair. Chair, you know, I think we've been sitting on these hearing for past couple of days now, and I think it's very important, Chair, to understand that there's a very clear distinction on what our role and responsibility is as a committee, and what we need to consider as a committee from all that is representing here in this committee. But secondly, Chair, also as members of this committee, we cannot be sitting here and be referred to as dealt with bigger people and so on, and whatever the case may be. We need to respect each other here. There's a process that we need to run, and it's important for everybody to be protected in this process. And there's been jabs and comments that have been made, whether to witnesses, whether to the committee, whether to you as a chairperson, and that is unacceptable. Neither are we going to sit here and be insulted or bullied, whatever the references may be, because we've got a responsibility to do justice to this process. And this process needs to be fair on all that participate in it, including Advocate Mpofu and Advocate Mkhwebane and her team. So I think, Chair, let's just hold the decorum of the House and not degenerate and throw comments and insults, because then we lose the whole purpose of this. I really plead with you, Chair, to chair this meeting and facilitate it in all ends. There's nobody who's special more than somebody else here. We all have a responsibility to play, and let's do that. Thank you so much, Chair.
Thank you, Honorable Nodada. That's in order. Honorable Luzipo.
Oh, thank you, Chair. I won't take your time. Can we agree that there is a process we agreed to? That let's go through that process. Where there is a concern about proceedings, can we all go to the back room as agreed? Or if you were a judge, I would say to your chambers and deal with the issue. For now, let's continue with what we are doing. All those issues must be dealt with outside this meeting. Thank you very much.
Thank you, Honorable Luzipo. It's just that some of these issues don't need a back room. They've got to be attended to on the spot in the meeting, because they are part of what the directives are asking us to do. So the point is taken, but it's because it's not just confusion between the evidence leader and the legal team of the public protector. Some of the issues go straight to this constitutional process that we're driving as the National Assembly. Thank you for that. Advocate Mpofu.
Thank you, Chairperson.
Sorry, I see a hand of Advocate Bauer before you proceed.
I do feel that I need to respond to the allegations made against the evidence leaders.
Yeah.
Having the allegation made that we have failed to disclose a guilty finding on the question of dishonesty in respect of this witness. I do not find in the guilty findings on the charges which Mr. Kekana faced to have included in charge 1, 2, and 3 a finding that says I accordingly find him guilty of dishonesty. I, during direct examination, expressly stated that he faced disciplinary proceedings, he was found guilty, he was dismissed, the matter went to the CCMA, it was dismissed, and his proceedings are pending before the Labour Court. It has not reached finality.
Thank you, Advocate Bauer, for placing that on record. Advocate Mpofu, can we resume?